And that will do it. Let's get cranking, guys. I've got a lot to cover with you in this hour. Coming up, Mr. Gottlieb will be here. He is here now, but he is tuned in right now and listening to this opening segment, and then we're going to go to him for the remaining 3 segments. Guys, tonight we're going to spend some time talking about a man whose name is synonymous with your right to bear arms. Every American gun owner ought to know this name, even if they don't realize just how much he's changed their lives. Of course, I'm talking about Mr. Alan Gottlieb. He's the founder of the Second Amendment Foundation. And if you've carried a firearm ever today, if you've purchased one, if you've taken a training class, if you've exercised your right to bear arms outside your home, even inside your home, chances are you've benefited from litigation that Alan Gottlieb and the Second Amendment Foundation either led or helped make possible. I want you to think about this for just a second. Most people know who the politicians are. We know them, good and bad. Most people know them. They know about the talking heads. They know the activists. But very few Americans know the names of the people who have actually gone into federal court year after year, decade after decade, building the legal foundation that protects our constitutional rights. Long-time listeners to this program have heard Alan on this show for well over 10 years. But we have a lot of new listeners around the country who probably don't know. And guys, he's the real deal. And that's exactly what Alan Gottlieb has been doing for over 50 years. The Second Amendment Foundation, folks, was founded in 1974. So kind of let that sink in. My wife was 2. That was nearly 20 years before the Brady Bill. It was 20 years before the so-called Clinton assault weapons ban in the crime bill in 1994. More than 30 years before the Supreme Court finally recognized what the founders had written all along, that the Second Amendment protects an individual right. Alan Gottlieb saw that need long before most people even recognized there was a constitutional battle coming or even brewing. Back then, the Second Amendment was often treated as a constitutional orphan. Many, and I could safely say most legal scholars at the time, claimed it protected only state militias. Remember that? Federal courts routinely rejected individual rights arguments, didn't even pay them any mind. The conventional wisdom in legal circles was that the Second Amendment simply wasn't enforceable by ordinary Americans. Alan Gottlieb didn't buy it. Instead of complaining, he went to work, and he built an organization dedicated to changing the law one case at a time. You know the moniker, winning our gun rights back one lawsuit at a time. Not through speeches. He didn't do it through campaign slogans, not through television appearances, although he made many of those and still does from time to time, but through litigation. Patient, strategic, long-term litigation. And that's exactly what's transformed the constitutional landscape we see today. When people think about landmark Second Amendment victories, they usually start with Heller. And yeah, Heller changed everything. For the first time in American history, the United States Supreme Court clearly held that the Second Amendment protects an individual constitutional right to keep and bear arms. The Second Amendment Foundation wasn't the lead counsel in Heller, but it did file supporting briefs in supporting this historic outcome over in Heller. And it was Alan Gura, one of the Second Amendment Foundation's attorneys, who won that case. Then came what I consider one of the most important constitutional victories of last century, and we'll talk with Alan about this in greater detail, but that's McDonald v. City of Chicago. Because this wasn't just another lawsuit, ladies and gentlemen. This was the lawsuit that made Heller matter everywhere. It gave Heller teeth. Without McDonald, states and local governments could have argued, and did, that they weren't bound by Heller at the time. Alan Gottlieb and the Second Amendment Foundation changed that forever. The Supreme Court agreed that the Second Amendment applies not only against the federal government, but also against the state. Every county, every city, every town, every village, as Clinton likes to call it, everywhere across the country. Every major Second Amendment victory since then rests on that very foundation. Then came Moore v. Madigan. And you've heard Alan talk about it on the case before, but this was Illinois, was the last state in America that effectively prohibited ordinary citizens from carrying firearms for self-defense. And you remember me eating crow on this program. I know Greg does. I had to eat crow. I said, if you want to carry your gun in Illinois, you're just going to have to move. It ain't happening. 2 years later, I ate crow, and it happened because of Moore v. Madigan and Alan Gottlieb and the Second Amendment Foundation. SAF challenged the law, and they won. Illinois became a right to carry state. Think about that for a minute, okay? One lawsuit fundamentally changes the law for millions of people. One lawsuit. Then there was Ezell v. Chicago. Sounds like an obscure case. We've talked about it here before. But it's anything but. Rhonda Ezell is just a phenomenal friend of mine. That case is anything but obscure. Chicago tried to make firearm ownership practically impossible after the loss by banning places where citizens could actually train. The courts recognized something critically important in Ezell. If you have a constitutional right to possess a firearm, you must also have a constitutional right to become proficient with it. That principle continues to influence Second Amendment cases today. Then came Palmer, then Grace, and then Wren. Remember Wren v. D.C.? We'll try to get into some of these with Alan today. But each one of these cases chipped away at what we would refer to, or I would refer to anyway, as discretionary permitting systems that allowed governments to decide who deserved their constitutional rights. Those cases helped lay the groundwork for the Supreme Court's decision in Bruin, where the court rejected interest balancing and told lower courts to look instead to our nation's historical tradition when evaluating firearms regulations. That wasn't luck, ladies and gentlemen. That wasn't coincidence. That was decades of careful litigation. Now, we fast forward to today. The Second Amendment Foundation has participated in more than 260 lawsuits. Again, more than 260 lawsuits, cases involving, I don't know, let's pick them. Let's go through a list. Public carry, magazine bans, semi-automatic rifle bans, age restrictions, sensitive places laws, handgun rosters, ammunition restrictions, ATF regulations or over-regulations, federal firearm disabilities, state prohibitions, emergency powers, think red flags, 18 to 20-year-olds. The list goes on and on. And today, as we speak together today on Armed American Radio, two of the biggest hardware ban cases in American history are headed to the United States Supreme Court. Those cases, those two, will determine whether governments may ban firearms owned by millions of law-abiding Americans. And you know what? They're Second Amendment Foundation cases. Again, the Second Amendment Foundation is right in the middle of the fight, folks. You know, we hear people say that elections have consequences. I say it, that's true, but court cases have consequences that last for generations. Legislatures change, presidents change, they come and go. Congress changes every 2 years, every 6 years in the Senate. But constitutional precedent can shape the nation for decades to come. That's why organizations like the Second Amendment Foundation matter so very much, because they don't simply react to headlines. Alan didn't react to a headline. He created them. And that's how we win. We don't just argue policy. We establish constitutional precedent. We don't just defy, or defend, I should say, today's rights. They protect tomorrow's. That's what these precedents do. And that's an extraordinary legacy, ladies and gentlemen. And the man who started it all, Mr. Alan Gottlieb, will be here for the remainder of the 3 segments. And I've laid out some of the top 10 cases I think are extremely important. And we'll talk with Alan about those, and we'll let him, based on this foundation, kind of move forward in this discussion. But guys, I will tell you this right now. You would not be here, as I said in my opening statement, you would not be here. We would not be here as a nation were it not for my next guest, Alan Gottlieb, someone you've heard on the program for years, but a whole new perspective. We're going to talk about where this journey began, the cases that changed America, what victories surprised him the most, the battles that still lie ahead, and why he believes the next chapter in Second Amendment jurisprudence may prove to be even more consequential than the last. I hope I'm not putting anything into his mind with that. Those are my thoughts. Ladies and gentlemen, it is always an honor to welcome the architect of modern Second Amendment law, and Alan Gottlieb, the founder of the Second Amendment Foundation. That architect joins Armed American Radio next, and we're going to talk about it in great detail. We'll be right back after the break. Go to the architect himself, the man himself, Alan Gottlieb, founder of the Second Amendment Foundation. Alan, you know, we always refer to Quang Nguyen as the Shredder. I believe I've got a new moniker for you, the architect. Welcome in, my friend. It's great to have you here, and congratulations on this historic, monumental month.
Yes, it sure has been, Mark. Thank you very much for all those kind words. But I didn't do this all by myself. And if it wasn't for the fact that God has helped me and put a great guardian angel on my shoulder to help guide me, and I've had great boards of directors and staff and millions of donors over the 50-plus years that have made this all possible, I wouldn't have been able to accomplish this. So it's been a great joyride for over 50 years. It's been my whole life. I love it. It's been great. I want to just thank everybody, many of your listeners who've helped made it possible.
Alan, I was in Phoenix with you back in February, and I watched you give a speech that was the most remarkable speech I've ever given, that I've ever heard you give. And it wasn't just myself that said that. There were others who knew you well, but you silenced that room when you essentially went off written script and just began to talk about the history of it. And I want to cover a lot with you, but I think because these two court cases coming up, we'll get to those. I want to go back. Like, you built like Legos. I mean, you have put together just through building blocks over the years. Was my assessment right that the Second Amendment had been treated as an orphan? Because you've mentioned this before at private conversations, and you mentioned this at AOR speech as well. But your cases literally built the foundation that brought us to Heller and that brought us to Bruen and everything in between. And then I want to break down some of these cases individually that I think matter and see how you rank these.
Yeah, you're not really wrong about any of that, but a lot of it doesn't happen in the courtroom. You know, when we first started back in the 1970s, there was really no case law supporting individual Second Amendment rights for all intents and purposes. And like I explained at the speech you referenced, we really only had one case we could really reference that took out, a law involving our self-defense rights, and it wasn't even a federal law. It was a state law in the state of Oregon, where the Oregon State Supreme Court unanimously said that overturned a conviction of a man that actually used a knife, not a gun even, to defend himself, and that it was ruled that it was unconstitutional to convicted him for using a means of self-defense. And that was really about it. And so a lot of this didn't happen in the courtrooms. It happened, trying to build the foundation so you could ever get to a courtroom with legal scholars, conferences, research, publishing, things that you could then cite in court cases to begin with. And back then it was like, we were in a desert. And boy, we've come a long way in 50 years.
Well said, no question. But don't sell yourself short, Alan. You've got a great staff, and I've sat in board meetings for a number of years. And we know where the genius comes from. Everybody on that board, past, present, and likely future, will know where that genius comes from. Let's go back to some of these cases, because the McDonald case, while we talk a lot about Heller and we talk a lot about Bruen, I talk about the McDonald case here, but I've ranked about 10 cases in order that got us here, I think, that were incredibly important as part of those building blocks. And since these were your cases, you can tell me whether I'm wrong or not, and ladies and gentlemen, Alan will. But the first one I mentioned in the opening remarks was McDonald v. City of Chicago, which I would argue is SAF's greatest victory because it incorporated the Second Amendment against the states through the 14th Amendment, making Heller enforceable nationwide. Every major state's gun rights cases today trace back to McDonald, and I'll never forget that being argued by that brilliant attorney, Alan Guru, who took a few of the justices during oral arguments off base a little bit with his due process comments. Let's talk a little bit about McDonald v. City of Chicago.
Okay, but first I want to go back to Heller for just a second, because the Second Amendment Foundation, while our attorney Alan Guru argued that case, it really wasn't our case per se. But we filed a very important amicus brief in that case that basically, I think, won us the fifth vote of the Supreme Court that made it all possible. And one of our problems was that it was going to be hard to overturn precedent from previous cases that basically didn't rule that the Second Amendment was an individual right. And we had to target a particular judge in a way that we could get him to vote our way without overturning anything. And that's where the phrase really came in about commonly owned firearms. And of course, that's what originated it. And it was, that decision, it got implemented because of it. which then, took us to McDonald. And of course, the Heller case was against the city of D.C., which is a federal enclave, and it only would apply to the federal government or federal, jurisdictions like the nation's capital. The McDonald case, we filed that. We knew we were going to win Heller, and we filed that McDonald case strategically the same exact day, like within an hour of the decision coming out, against the city of Chicago. Chicago also had a handgun ban like Washington, D.C., and so we challenged it, and then we had to get the 14th Amendment incorporation issue resolved, or you couldn't have challenged it. The Supreme Court not only overturned the handgun ban in Chicago, but incorporated the Second Amendment through the 14th, which then, as you mentioned, opened up the door for all the litigation against all the states, cities, counties, townships, et cetera. So that probably was the most important one. We wouldn't have gotten there probably without Heller. But McDonald was strategically filed, again, the day we won Heller, and our opponents, all the anti-gun groups, talked about if the court ruled our way, it would open the floodgates. Well, courts would be dominated by Second Amendment litigation. They don't have time for it. They don't understand it. It shouldn't happen. Of course, they were semi-right about it opening the doors. They weren't right about the rest of it.
Well, that's not unusual, them not being right about the rest of it. But ladies and gentlemen, again, we're talking about the building blocks here. And again, the floodgates did open. Of course, McDonald, Moore v. Madigan, and that obviously a direct result when Chicago got slapped with the Constitution, or Illinois did. Chicago decided to try to get around it, and this case forced Illinois, which was the last state prohibiting public carry, to adopt concealed carry, the first major federal appellate decision recognizing a right to bear arms outside the home. And in this particular case, they did, this is where we begin to see, in my estimation anyway, a playbook from the left of how they were going to chip away as we continue to win cases. We saw kind of a strategy building here, did we not? And Moore v. Madigan was another case that we won.
Yeah, I want to back us up ahead because this is an important case. It doesn't get a lot of play because it didn't go to the appeals court level. It was won at the trial court level and died there. But the day we actually won, the McDonald case against Chicago, that same day we filed another suit known as Bateman versus Purdue.
Well, I have that as number 6 on my list. Alan, let me stop you right there. I have Bateman as number 6. Guys, when we come back from the break, we're gonna go through these top 10 with Alan because and Alan will interject along the way where he thinks I might be wrong, because he's there. He's been there. These were all his cases, ladies and gentlemen. I say his cases, meaning your cases, our cases, particularly if you're a member of SAF. We've got 2 more segments with Alan. Buckle in. We're going to move quickly, okay? See you on the flip side of this break, just a couple minutes. To Mr. Gottlieb. Alan, welcome back in, my friend. Let's keep going. You mentioned the Bateman case, and that's the case that prevented states from suspending Second Amendment rights during emergencies. Yeah,
we filed that case the day we won McDonald. North Carolina had an Emergency Powers Act that denies Second Amendment rights in cases, things like snowstorms, hurricanes, and we won that at the trial court level. And, of course, North Carolina, not being an anti-gun state, just didn't appeal it, so it didn't make a whole lot more press. But it did have a great impact. About a dozen other states that had these similar emergency power laws then all repealed those emergency power laws that denied Second Amendment rights. So it had a very great impact. I just wanted to go a little bit in chronological order with that, because then you jump back to Illinois to, the state carry case. But we had before that one, we actually had to deal with Ezell, which you mentioned in your opening monologue, because then Chicago lost, and of course they weren't going to go away about gun ownership. So in order to own a handgun in your own home, they made you take mandatory training lessons with banned gun ranges. We went through a couple different cases against Chicago, time and again winning those cases, which set precedents for gun ranges all across the country, not just in Illinois. And then that took us to your case of Carey in Illinois.
Yeah, and now, again, I've got 10 of them listed, ladies and gentlemen, and they're not really in any particular order. They're just what I believe are the 10 most important. We'll talk with these with Alan, and he will interject as he sees fit. Number 4 on my list, of course, was Wren v. D.C. That was a case we talked a lot about here on the program back in the day. But that case effectively ended D.C.'s good reason carry requirement, and it became one of the strongest appellate precedents protecting public carry before Bruin. And it was, as you remember, Alan, very well, will they seek cert at the Supreme Court And all the blue states got together and said, "Don't let it stand. We're going to lose it everywhere." So it was never appealed to SCOTUS for cert. Is that right?
I believe from memory that is correct. There was a number of carry cases we've won across the country that didn't get appealed. For a while, our opponents took the position that if they lost in a jurisdiction limited to that jurisdiction, don't appeal to the Supreme Court because then it becomes national. And they learned that lesson in a couple places. Particularly in the Heller case in D.C., because when they lost it at the appeals court level, they had to decide if they were going to take it up or not. And, of course, they ended up taking it up, and when they did, they lost, and it became national.
Yeah, so that was a good legal strategy on their part, at least in Wren, right? Not to do that. So I guess they figured that game out. My number 5 on my list is Palmer v. D.C., and guys, the Palmer case, all these Second Amendment Foundation cases, of course, invalidated D.C.'s complete ban on carrying handguns outside the home, forcing the district to create a carry licensing system or a scheme, however they get involved. But it forced them to do so because, remember, Heller was about keeping a handgun in the home. So Palmer just expanded that, did it not?
It expanded that, and there have been a couple other cases as well that expanded it, which led us to the problem where now when places had to give you a permit to carry, they start to limit places where you could carry it, making it basically ineffective. Having a permit, it didn't do you any good, which took us to the whole new area of Second Amendment litigation.
Yeah, Binder up. I've Binder up on this list. I know that was a case that you talked a lot about on this program, but it was one of the first major victories limiting lifetime firearm prohibitions for individuals convicted of certain nonviolent offenses, correct?
Correct. And, of course, we've won that case and then a number of other ones subsequently as well. But in most of these cases, a lot of times it only applied to the individuals as an applied case. It didn't knock out the law itself. Of course, this past year we've seen that change a little bit with SCOTUS, and now it's opened the doors again. But if it weren't for some of the earlier cases that you referenced, we couldn't have got anywhere near where we are today, and we're still winning and going to continue to win and moving forward.
I love it, and we're going to go in a lot of detail about the winning coming up, ladies and gentlemen, in the final segment. I have the Grace case, Grace v. D.C., not a case that got a lot of coverage, but it struck down because D.C. tried to do what they all do, kind of like Illinois did or Chicago did in Illinois. It struck down D.C.'s restrictive good reasoning licensing scheme, and that was really the case that paved the way for Wren, I think, because I don't have these in any particular order, but wasn't the Grace case the one that actually paved the way for the Wren v. D.C. case?
I'm confused myself now.
So many wins, Alan. Are you tired of winning yet?
Well, we've been involved in over 260 cases, and we have over 50 of them ongoing right now. Yeah. It's really hard for me to keep track of who the plaintiffs are, but thank God for these plaintiffs, because if it weren't for these people willing to put their name on the dotted line on our legal cases, we couldn't have brought them either. So I want to thank all the plaintiffs historically that have made all this possible, and we all owe them a debt of gratitude.
There's no question about it. And to go back to your genius on this, guys, go back and remember what Alan just said. The day the Heller decision came down, we knew we were going to win it, and Gottlieb and the Second Amendment Foundation filed the McDonald case immediately that day. That's how this strategy plays out. I want to take you to the Young v. Hawaii case, because Second Amendment Foundation ultimately lost that in an en banc panel hearing. But that litigation helped build the historical record on public carry, and that influenced later cases after Bruin, did it not? Is my correlation there right? Because if I look at Young, that's what I see. That's my takeaway from the Young case.
Well, Mark, I hate losing a case, but sometimes losing the case still gives you some benefits. And you're right that it helped bring things to the public record, which was needed in future cases. So to that extent, you're 100% correct.
Now, Woolard is my number 10 case. And the reason I think this case is important, they're all important, ladies and gentlemen. All 260 cases that Alan's been involved in are important. I'm highlighting just a few of them on my list. But the Woolard case was a very early challenge to Maryland's good and substantial reason. Do you see how the building blocks are happening here, ladies and gentlemen, in different areas, how these cases build on each other? It was an early challenge to Maryland's good and substantial reason requirement, and the loss highlighted the circuit split, which is so important, that in my estimation, was later resolved by Bruin. This is how these tie together. That's the way I'm looking at that one anyway, Alan.
Yeah, sometimes, again, these losses help you out. I hate losing because, quite frankly, we never should lose any of these cases. We are right, but getting judges to not be political sometimes is important, especially when they're appointed or nominated by anti-gun presidents and parties that, quote-unquote, don't respect our constitutional rights to begin with. So it's hard to say which of the most important ones are. I think historically the most important ones probably are the ones we win, not the ones we lose.
Yeah, although sometimes losing can create that split, as we were just talking about, ladies and gentlemen, because as you know, you've heard Alan say this many times on the program over the years, the court takes less than 1% of their cases. Now, Alan, I know we're going to be told, I haven't been told yet, but I can tell by looking at the clock that we're going to take a break. When we come back, I want to talk with you about Amy Barrett's concurrence in the Wolford decision, number one, because I want to, looking back in hindsight, it all begins to come together to me. I want to give you my theory there and then let you talk about the two cases that were just accepted for cert, you know, and we'll go back to Kavanaugh's opinion. We'll talk about Barrett. I've got an interesting theory there, and I want to get your take on all of that, because where we're going forward, ladies and gentlemen, is where we're going to go with Alan next. I wish we had more time. There are so many other amazing cases that we could cover, and I hope I got to the 10 that really kind of helped lay that foundation and that building block up, and we'll let Alan mention a couple more if he deems so during the break, if there's a couple more that pop up. But very important because of what just happened over the last 2 weeks, and we'll go into great detail with Alan about that just as soon as we come back from this break. Armed American Radio is being heard on hundreds of radio stations around the nation. I've got some new affiliates to mention, including Ann Arbor, Michigan, WHAM, WAAM. Wow, I used to live in Ann Arbor when I was 9 to 15 years old. Lots of friends out there. Some of them might be listening. Lots of firsts between 9 and 15. Welcome in, Ann Arbor, Michigan on WAAM. We'll be back right after this with Alan Gottlieb. Back to Mr. Alan Gottlieb, founder of the Second Amendment Foundation. Alan, moving quickly here, let me just set this up in a nutshell. I read Amy Coney Barrett's concurrence in Wolford, and I thought it was very strange. And it got stranger the second, third, and fourth time I read it, because all she did was reiterate everything Alito did. Well, a couple days later, things become clear to me. She knew at that time that the court had accepted cert on those two cases, going the hardware bans that we're going to talk about with you briefly. She knew that. We didn't, but she did. She also knew that she was going to get hammered on the opinion by joining with Roberts and the three liberals on the delayed voting and the vote. Forgive me for not knowing the name of the case. And I think what she did in the Wolford case was let America know, I have Second Amendment chops, because if you agree with everything Alito wrote, it will be impossible for her to vote against the two cases coming up in the next term at the Supreme Court. Am I right?
Well, I'm pretty sure you're right about everything on the gun side of what you said. I'm not sure about the voting rights part of it, but she obviously knew that the court has accepted the two Second Amendment cases for the next term, both SAF cases. So that part of it, I think, is a no-brainer.
So, yeah, guys, I've been talking about this for the last week or so. She was showing America her chops. And, Alan, I'm going to go right out on the record right now. It's a 6-3 decision. That decision comes down 6-3 in the next term, as long as, God willing, everything stays on the court the way it is today. Go ahead.
Yeah. Well, Mark, just so your listeners know what you're talking about, the Supreme Court accepted two cases for the next term. The Second Amendment Foundation has filed on the solvent bans, one in the state of Connecticut and one in Cook County, Illinois, and they've combined them both for oral arguments. So now your audience knows exactly what you're talking about. And I think when you talk about a 6-3 ruling, I think that's pretty solid that we could expect a 6-3. I'm hoping for a 7-2, but again, I keep hoping that one of the Democratic nominated judges on the Supreme Court will give up the politics and go along with protecting Second Amendment rights. There's 5 major cases. It hasn't happened so far, but maybe number 6 will be the magic bullet.
I'm curious if you think it's 7. A lot of people have a lot of reservations about Roberts, and you know, when it comes to these cases, Alan, we're 5-0. He's ruled with us in all 5 of those cases. I think that makes it impossible for him. Well, maybe nothing's impossible, but it certainly would fly in the face of everything that he has written or everything that he has concurred with or voted with in those other 5 cases. I don't see him going anywhere. Where do you see that 7th vote coming? Any idea? Or who would you be hopeful that one of the 3? Can you want to name one?
Well, I don't want to name one. It could be one of 2 of them. But Sotomayor referenced the fact that semi-automatic firearms, known as assault weapons, are in fact commonly owned. She wrote that in the decision that she didn't go along with this on, but she admitted it. And so there's a chance there that maybe she's in play or in motion. And then there's Kagan, who understands where we're all coming from on gun rights, but politically she hasn't been there with us, so she hasn't ruled in our favor. So there's some possibilities there. But 6-3, I think, is pretty solid. I think Roberts has taken the position to move slowly, and that's what's built up our frustration because a right delayed is a right denied. So he's moved very slowly on taking some of these Second Amendment cases, but ultimately he always turns around and supports our position. So I'm pretty confident we will have him.
Well, when you look at Kavanaugh's opinion after the cert was denied in the Maryland case, which was your case as well, in the Fourth Circuit, which should have been taken in my estimation. Maybe not. It might be too early to tell right now. That's the impatient mark coming out. But it seems to me that we see the court building upon itself here in a post-Bruin environment, and what Kavanaugh wrote has ultimately come true. It leads me to believe. Now, and I think you're right about Sotomayor, by the way. I've talked about it on the show. It's going to be very difficult for her, kind of hypocritical there, because she did acknowledge in that ruling that these were guns in common use and that they could not be banned because they were in common use. So, I mean, if anybody's going to move on that, it would be Sotomayor. That would be my guess, not putting words in your mouth. Ketanji Brown, she already respected, supposedly, the precedent set in Bruin and then went right back and didn't care about it in the Wolford case, because, of course, I'm talking about the Hamani case, which was 9-0. So a lot of interesting dynamics in play. Let's assume we win those cases, which I think I'm fairly positive we will win. How does that reshape the landscape going forward? And would you want to be in the anti-gunner's shoes? I'll let you take us to the break with that one.
Well, no, I wouldn't want to be in their shoes. I wouldn't want to be in their shoes right now either because I don't think they have a winning hand to play. But what they do is, like I've always said, is they will come up, they will not respect the decision. They will say the decision was wrong, and that, quote unquote, they'll come up with other new creative ways to try and get around the Second Amendment rulings. The particular one that they're really dying for right now is stacking the court and adding 4 new judges to this U.S. Supreme Court that would be anti-gun so they could overturn the rulings. I mean, they're never going to go away, So they're very creative. This battle, unfortunately, is not going to end by these 2 rulings, but we definitely will be sticking a dagger in the heart of their anti-gun premier area of trying to ban semi-automatic guns and calling them so-called assault weapons. We are going to win it, and that's going to impact like 12 other states and the District of Columbia. And so that whole issue is going to be off the table legally for a while, until maybe they can stack the Supreme Court with 4 more anti-gun judges, expanding the base of the court,
30.
Because they know they can't win with the current base.
Do you think, we've only got about 20 seconds, do you think they will try, because that will be a pretty much a slam dunk case if guns can't be banned. But they're going to try, aren't they? I quote you all the time on this show. Ladies and gentlemen, Alan has told us many times, he just did. Their creativity knows no bounds. They're going to try something, aren't they?
Yeah, well, the big thing for all of us right now is the upcoming midterm elections, because that's going to determine who controls Congress, the Senate, and who gets onto the
60.
Supreme Court, or if the court gets expanded. So gun owners now need to move their attention between now and November to the elections.
Yeah, because their planning is strategic, ladies and gentlemen. That's what we've been talking about. They're moving on the midterms now and in hopes of 2028 as well. Don't believe me? Go follow that goofball Gavin Newsom over on X and read those posts from Chris Murphy on X every day. Alan, we love you, and you are loved by millions. Congratulations to you, my friend. Honored to have you on this program for so long and laying out this foundation that you have built with the Second Amendment Foundation. Thank you for everything that you've done. Ladies and gentlemen, I'm a member, life member. You can join at saf.org, saf.org, and we certainly hope you do. Ladies and gentlemen, if you're watching on YouTube, make sure to like and subscribe us over there. Get involved in the comments. Coming up next, yeah, this is going to be a good one. Jared Yanis and AWR Hawkins, a 1-2-3 throat punch with us, guys. We'll be right back. Don't go away. 6 minutes after. I got to say it, Jared. You're looking good, baby. You're looking good, and I know you're sounding good. How you doing, man?
Good, man. It's always good to be here with you. How's it going?
Oh, it's going great, man. Now, I'm going to just preface the start of this conversation with this. I've watched your videos for years. Have you ever been this busy?
No.
It's been crazy, hasn't it been? I mean, you've been putting out how many videos a day?
Anywhere between 1 and 4 lately. It's been a good couple weeks for us, but we can't let our foot off the throttle.
No, we can't. That's why it stays busy, ladies and gentlemen. And Jared and I had a fun off-air conversation. We talk a lot just a couple days back. I said it's kind of like every time I'm afraid to take lunch because I'm afraid I'm going to miss something else breaking, and you agreed immediately and then had to go because you were getting back to putting your second video up for the day. Now, on top of that, you just traveled to Washington, D.C., Jared, so let's go there. You had an opportunity, and I did watch the full hour and 38-minute long-form video. And then the segment split up. And before we get started, tell people where they can go watch that, of course, and then let's get into the meat. Go for it.
Sure. So head over to my YouTube channel. I was blessed to go to the ATF headquarters and interview not only the director, but the chief legal counsel for ATF. And I think there's a lot of information in there that people want to know. And it would make me feel much better if people watched it.
Yeah, it's good. It's real good. In fact, ladies and gentlemen, it's so good. My plan was to have a series of clips that we could break out. But, you know, his answers, Jared, correct me if I'm wrong. For example, let's start with the pistol brace, okay, which was a big part of the conversation. You've got about a 10 to 12-minute video out on that. I really want to get into the meat of that, not necessarily because of the brace itself, but because of what he said. And when I went in and I looked at trying to pull these clips out, the answer was so long, I wouldn't have been able to do it in a small chunk. So I want to just be able to have an opportunity to talk with you about it because I can hear a lot of people on our side being very concerned with his answer, and I want you to break down why they would be and why not. And I'll set it up with this. You flat out asked him about the pistol brace rule, flat out asked him, and he gave about a 9-minute response before I heard anything of any significance relative to what I wanted to hear. But that's somebody who I'm waiting for a specific thing. Break it down for us.
Sure. First off, I will preface by I don't support any infringement. I don't support rules by ATF. With that said, I had to go in there and be willing to have the conversation and build a rapport. So he had answered a question about the pistol braces on 2 other interviews he's done with people in our realm, Colion Noor and Shermichael Singleton, both friends of mine. And I thought that the way he left it was kind of vague, and I got a ton of feedback who wanted me to get more information on that. So when he did answer the question when I pressed, he did answer it 100% by the law. Mm-hmm. And regardless of what we feel or what we want to happen immediately, he is bound by the law Congress set because he's in law enforcement and, you know, the administration is the executive branch. He's basically telling everybody, we're not coming after you. We're not enforcing this rule. However, if you do get jammed up, it's somehow in law enforcement, whether it's a domestic or anything else, and the local cop has to ask ATF to classify an item that's under 26 inches in total length or under 16 inches in barrel length, according to the NFA, which is very specific in black and white, they will answer it by the law. So it sounds like your pistol brace firearms could still get you into a jam. ATF's not jamming you. It's going to be the locals. However, that could change the next director we get.
Yeah.
But we need to direct our anger in the right spot. The director of ATF can't change anything, honestly. And I'm not sticking up for them at all. Congress is the only people who can change that, or these lawsuits we have by SAF, GOA, FPC, NRA, blah, 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 looking to get rid of that portion of the NFA for SBRs, SBSs, and cans.
You know, what I heard from him was a little bit disturbing. Now, I've interviewed his boss, Todd Blanche. I have not yet had an interview with him. I intend on doing that on the program in the very near future. But having said that, I heard you don't have anything to worry about your government coming after you, and all I could hear was Ronald Reagan, the famous 9 words, I'm from the government, and I'm here to help. So he basically is asking us to trust him that they're not going to come pounding on our door. And he made it very clear in your interview with him at the outset of that 10-minute video today. Guys, make sure to go watch that at Guns and Gadgets. If you can do it when you get off the air today while it's fresh in your mind, please do so. Very, very important. He made it clear he had a brace. He made it clear that he registered it during what you brought up as the amnesty period. Now, Greg, I found mine again. I don't know where it went, but it came back. It just came back to me. I lost it for a while, Jared. I don't know where they all went, but they're back now. Those words concern me, and I could hear a lot of members on our side saying, oh, okay, because our basic framework is based around we don't trust government, period, particularly when it comes to our Second Amendment rights. So I'm just going to ask this question of you. Somebody from the administration is likely listening. Why should we believe him?
You know, I did speak with the director on and off camera for quite a while, and I did get a good feel of him. I do have a good judgment of character. It's been a strength of mine throughout my career. I think he's not something or someone we need to worry about. He has at least he's saying the right things. He also answers to people, and that's who we have to worry about. I don't trust government, period. I told them to their face, I don't believe in the rules. They're infringements. But these guys, you know, you've heard this phrase before, I'm doing my job. And it's unfortunate. And if you remember, I did a video several months ago where ATF had employees who were answering the phone in the NFA division and who shouldn't have been giving out information. They told everybody that, you know what, we don't care what's on it as far as a brace or a stock. If it's under 16 inches, it's an SBR, and according to the NFA and GCA, we're good to go. And that's kind of what the director told us, and that's what people need to understand. So know what's in your collection. Don't do anything stupid. You know, don't get into a domestic. Don't go robbing a bank. Don't do anything dumb, and I think you're good to go. But I don't trust the government.
There's that but. And we were left with that but. Now, I'll tell you, I know I don't have any fear. I didn't fear Pam Bondi, okay, because I knew she respected who her boss was. And I made that clear on this program a number of times. I do not fear Cicada at all. I certainly don't fear Todd Blanche. I've sat down and had a conversation with him on the radio, and I talked with him outside of that off the record as well. And he made it very clear to me that their goal was to lock up our Second Amendment rights, even if we lose the midterms. He said it won't matter. He said we don't want to lose the midterms, but even if we do, our ultimate goal here is to lock up our Second Amendment rights so for future generations we don't have those concerns. I didn't come away from that. Again, I want to point out, ladies and gentlemen, I'm not hammering Cicada on this at all. I'm talking about the position that he's in as the director of the ATF. He made it very clear. It's not going to be ATF that's banging on your door. Don't get yourself in any trouble. But, and there was that but again, it's the letter of the law, and they will, and he did make it very clear in your interview that he will, in fact, enforce the letter of the law. And he also made it very clear. We're getting ready to take a break, Jared, so I'll take us to the break with this. We'll come back and discuss it. I'll let you break down what else you felt was very important in that interview because you conducted it. It was all dynamite. But we're going to run out of time. So let me just do this. When we come back, we're going to go right back to Jared. Ladies and gentlemen, you know where to go. It's armedamericanradio.com. Please support all of our great partners. You can find them all at armedamericanradio.com. And that's including Bud's Gun Shop, Pendleton Safe, and our newest sponsor, Silent, slnt.com/AAR. Put your cell phone in one of those Faraday bags, and guess what happens? Poof, you disappear. It's pretty much that simple. I've been using them for years. Armed American Radio's Monster Cast continues. We'll be right back with Jared. Because the segment's going to fly right by. Quick question. Why was Leitner there? Was he there because he didn't want Cicada getting in any trouble on some probing questions, do you think? Was that part of the arranged deal when you went up to D.C. this past week?
No, actually, when we were hooking up to set up the date, I was specifically asked if I wanted to have Robert there, and I said yes, because he is a very, very smart guy, and he's someone who has a lot of good insight on the behind the scenes and like the new rules and what they're trying to attempt to do, which is to make it much harder for that next administration to flip things on their head once there is a change.
Which is why, while I don't trust the government, it's why I trust these men individually, because I've had conversations personal. So I trust them individually. But, and I, you know, when you talk about their ultimate boss, we're talking about Donald Trump, who is the individual who has put all of this in motion to see to it that our 2A rights are, in fact, locked up permanently. I have no fear. Do you have any other fear of anything above them at DOJ going up to the White House that we need to be concerned with? Is there another butt in there somewhere that could happen from the White House?
I don't think so. I think the pushback Donald Trump got from take the guns first, due process second. He learned a very, very painful lesson on that one. So I think he's going to stay where it is, which is why he even mentioned the Second Amendment last night when he was addressing the country for the 250th.
All right. He made very clear that this was Congress's responsibility. And we don't have to just talk about that in terms of pistol brace. We can talk about other regulations, et cetera, can kind of get, you know, mixed into the fold here. Do you get the sense that are they pressuring Congress to help them along the lines behind the scenes? Is SCOTUS involved, or could he be, or even should he be, in saying, look, guys, you got to fix this because you're making my job difficult. I'm very pro-gun. I want gun owners to trust us. I don't want them to fear the ATF, and that's going to require you?
Well, I don't think he can do that. That's not his role, right? You can't just walk up to a senator or a congressman and say, you know, this is what you need to do. He did make it very clear that he would be willing to guide them and advise them on things they could do to make it easier for the American gun owner. But ultimately, Americans need to put pressure on their representatives and senators if they want anything to happen, or be that change and run for office and maybe be the one we need in there.
What other changes? I asked this from a position of knowledge because I watched the full videos and I brushed up on them again today. But I want to get your response really without a question. Some of the concerns that you had, or maybe not even concerns, but for example, ATF right now is getting ready to put more public questioning out there, public comments. You want to explain why and what they're doing there? What changes can we foresee based on your conversation from SCOTUS?
Sure. Actually, one of the things I was very surprised to hear from them is they look forward to reading people's comments on these new rules. 37 or 39 we're up to right now, and they want our feedback, whether we're for it or against it, or we would be for it if this would change. And they're really looking to make it easier on the legal, lawful American gun owner and focus on criminals, which is, when's the last time you heard an ATF director say that?
Yeah.
But some of the changes are, like, if you want to have an SBR, you can use, if you want to make an SBR, you can use the marking that's already on that gun instead of re-engraving it. They want things to be done faster as far as NFA paperwork and times. For instance, utilize your driver's license picture instead of submitting your two passport photos.
Time after time after time.
Every single time.
Right.
Yeah. It's crazy. Yeah. They do have some good ideas. I did tell them, I still don't think you have the ability to make rules. Like, what would George Washington say?
Right.
I understand why they're doing some of the ones that they're doing. For instance, they want to get rid of the lifetime of keeping records from FFLs that go out of business. Right. Before Biden, it was 20 to 30 years. Biden made it lifetime. They want to go back to that 20 to 30 years, specifically because when they do traces on guns found at crime scenes, they get hits up to 20 to 30 years, and anything after that, the way he explained it to me, is not really helpful, so they don't need those. And part of that rule would be to destroy all of the records after that mark. So the ones that we're all worried about, you know, you hear the billion transactions they have, they would get rid of that. How do we ensure that? I don't know, but that's what the rule is.
Well, we have to trust government here, Jared, okay? We have to trust that these men are telling us the facts. And again, I don't believe SCOTUS is in any way misleading anybody. I know that he feels that, and he does want to get that taken care of. But again, the proof is in the pudding, and at some point we hear that comment that you made in the previous segment, you know, I'm just doing my job, and those are scary words too. All right, let's move forward now. Huge week, cert granted. Here we are. Now we've got it. Gottlieb thinks it could be 7-2. He believes Sotomayor, and he didn't, I kind of threw Sotomayor out, although he mentioned her. She made those statements that you and I have talked about before that might likely come back to bite her, and I believe it was the Rahimi decision when she said that guns are in common use, can't be banned. She respected that precedent. Therefore, shouldn't that be a 7-2? We know Ketanji Brown's a no. We know Kagan's a no. But could we see 7-2 coming up in a victory in a hardware, these two hardware cases combined in oral arguments?
Yeah, that's what I think too. It would have been 6-3 if she didn't open her mouth, but now she's kind of locked herself in a corner if she wants to keep any type of honor.
Yeah.
But I also think one thing that many people aren't discussing is they held over the Duncan case, and that's the magazine ban case, and they're not done with that. So they'll take a month or two off here, and then we might actually have the hardware with the ARs and the hardware with the magazines. And it could be a really, really good term next year.
Yeah, let's explain to listeners what Jared means by that, ladies and gentlemen, is that case is still alive and has not been denied cert. So any idea of when they could or might or why they're holding off on that now? I mean, why didn't they just go 1, 2, 3 throat punch like our banner up here says on the screen?
Well, knowing how they've been operating and how they go slow with the Second Amendment, I think they'll probably hold that case. They'll keep punting it every time they have an opportunity to give it cert until we get something with these hardware cases. And then hopefully they don't GVR it, which is grant certiorari, vacate, and remand. But maybe they do hear that case towards the middle or end of the term, and we get a total slam dunk in a decision with the two hardware cases and the guns and 30 the mags.
And I guess it would make sense to me that they would wait and see how the two hardware cases turn out before they do that. But I don't think it's not going to carry out way long into the term. It's going to have to be fairly quickly. Do we know when oral arguments are scheduled yet?
I don't believe they've been scheduled yet. I haven't looked since they ran away for the end of the term, but I'm not sure.
Well, we're getting ready to take a break. Jared, man, I love you. Guns and Gadgets, man. Let's help you get to 1 million, guys. Gunsandgadgets.com. Guns and Gadgets over at YouTube. It's Guns and Gadgets at YouTube. Like, subscribe, comment, share. You know what to do. You watch YouTube all day long, and you've seen Jared out there. Jared, great work as usual, man. Thank you for being right over at AWR Hawkins, Breitbart News. My other brother from another mother. AWR, how you doing, man?
I'm doing great. Great to be with you.
Oh, always a pleasure. Did you have a good 4th of July, I hope?
Oh, yes.
All right, good
Yeah,
deal.
I did.
So listen, I just had Jared Yanis on. The 1, 2, 3 throat punch continues, A-dubs. You had some information. We were talking. He just interviewed SCOTUS, which you did as well a few weeks back in D.C. when you were up there. And you're now reporting, and I found this interesting, that SCOTUS told you just this past week that his agency has actually worked to speed up the approval process for Virginians trying to buy guns before the state's gun ban took effect. Now, of course, there's an injunction there, but that's good news, is it not?
Oh, yeah, it's good. Yeah, I was, Robert and I we talked on Wednesday, I believe. No, we talked on Thursday and talked about that. And so, yeah, what I like about it is it's in keeping with what he said, that there's going to be a new direction at the ATF. It's going to be a friend to the law-abiding gun owner, not an enemy. And if anybody's ever made good on their word so far, he's making good on his word. And so I think we're fortunate to have him as an ATF director.
Oh, there's no question about it, and he did make very clear to Jared in his interview, and I know he did with you as well, that while they're good friends of gun owners, they're still bound by law. And Congress has some splaining to do, correct? In changing some of this nonsense.
No, that is true. He doesn't have the opportunity to just arbitrarily go against law. Doesn't have that opportunity. So you're right. So he's still bound by some things, but I'm writing a piece tomorrow, and I want so bad to tell you, but I'm not, because I don't want somebody to hear this and then quote it in their own piece. But I'll tell you a few things tomorrow. I'll just everybody keep their eyes and ears open. I'll be doing a post at Breitbart tomorrow. I'll tell you some plans that he has.
Guys, it's real easy to find AWR's work over there. You can do just what we do, and we do it every day, all day long. We're constantly refreshing the screens. Just pull up whatever search engine you use, AWR Hawkins, Breitbart News, and you'll get a complete rundown because it will come up. The first one that pops up is AWR author at Breitbart. Make sure to click on that, and you can keep up with AWR's work as it gets out and gets published all day, every single day. I as much as I hate to do this, A-Dubs, I got to go here. I got to go to Taylor Swift and Travis Kelce. Why am I doing that? Because you put a great piece up that reminds us they hate our guns, but boy, they love their guns. And the title of the piece at Breitbart, ladies and gentlemen, is From Gun Control to Gun Patrol. U.S. Army over 120 police turned Madison Square Garden into a fortress for Taylor Swift's star-studded wedding. You try to turn your place into a fortress in New York City and see what happens to you. AWR, the hypocrisy drips everywhere, doesn't it?
Oh yeah, it's all.
Golly.
You know, she spent the last few years bragging when she donated to March for Our Lives. She's done numerous things, made comments in support of gun control, and but it's the classic. This for thee, not. I mean, this for me, not for thee. It's a classic deal, and it's laughable. It's not a bit surprising, but it needed to be highlighted because people need to remember how hypocritical these people are.
Yeah, and Mondani.
And
let
me just
surrounded
say
by
this.
guns.
I want to throw
Go
this
ahead.
in. I don't even care if Taylor Swift hates guns. See, I don't care because then what she needs to do is not own a gun. That's fine. But she doesn't need to spend money trying to keep me from having a gun because she doesn't like guns. That's the hypocrisy that I'm pointing out, because she wants to spend money for a group that wants to keep me disarmed, and then she gets married and has 150, 160 plus police officers of various levels armed, keeping her safe. It's a joke.
Yeah, and as a multi-billionaire that she is, I can promise you, ladies and gentlemen, she is absolutely surrounded by armed security. I don't know too much. I don't pay any attention to her. I would recognize her voice, but I don't know her music. And that's not saying anything negative. It's just not what I listen to. I don't listen to that pop. I guess there's a few songs I might.
Well,
know,
last time I was in your car, that's all we listened to. You said, listen to this. And it was just Taylor Swift.
He's lying, ladies and gentlemen. He's lying. He couldn't hear it anyway because the top was down. But regardless, the hypocrisy here, though, again, I don't know much about her activism, but I can certainly see that she would kind of play that way, although Kelce seems to be somewhat conservative. So I don't know. We'll see what happens. But the hypocrisy, I do appreciate you pointing that out. Now, because we have the Higgins and Viramontes cases, that's Grant v. Higgins and Viramontes v. Cook County. Those are the two Second Amendment Foundation cases that have been granted cert. We had Alan Gottlieb on for the first hour of the program, and I know you've spoken to Alan a lot over these very busy last few weeks. These cases are being consolidated, and of course the ruling it will determine whether AR-15s and similar rifles are protected by the Second and 14th Amendments. We're pretty confident that's going to happen. But there's a California case currently before the Ninth Circuit. That's Miller v. Bonta, and it challenges California bans similar to those challenged in Higgins and Viramontes. What did the Ninth Circuit do?
They just they issued a stay. They're going to wait and see what the Supreme Court does. And to be honest with you, I can't blame them because they're probably going to uphold the Ninth Circuit. Would probably uphold the gun control. And they don't want to be humiliated, and they're going to be humiliated. If they make that move right now, then when the Supreme Court hands down their decision, reminding people that, yes, the Second Amendment does protect commonly owned AR-15 rifles, then it's going to just humiliate the Ninth. What I like to think, I'm going a step further in my own mind, is that some of these liberal courts are getting tired of just being humiliated and reversed and vacated and everything else. And I hope they are. I hope that they wake up tired every day. And I hope that it just keeps getting worse for them. And so the Supreme Court so far has been doing a bang-up job. And I can't wait for their ruling next year on the cases you mentioned.
Oh, God willing, we're breathing at that time because I know how that's going to turn out. I know we're going to take a break, but when we come back, I want to ask you a little bit about that, just 60. To get a prediction. We've got 60 seconds, so let me go here. We have enough time. Thank you, Greg, for that. AWR, Alan felt that, upcoming could be 7-2 because of Sotomayor's comments in what I believe was the Rahimi case, where she absolutely flat out, and we talked about it here, guys, and at AWR, I think you and I talked about it as well, when she acknowledged that guns in common use can't be banned. Is that statement going to come back to haunt her? Could that be a 7 in that decision rather than 6-3?
I'm going to make a guess that's wild. I'm going 6-3 or 8-1, which is a very weird ruling. But I believe Jackson is going to be the immovable one. She is an ideologue first class. So it wouldn't shock me to see everyone realize this is an indefensible position to call ARs unprotected. It wouldn't shock me for 8 justices to say that, and then Jackson to go, they don't have protection.
All right, we're getting ready to take a break. Hang in there, ladies and gentlemen. We're going to be right back after this. I think when we come back, I want to stay in California. Let me go to that 8-1. I'm making a note of it right now. That's interesting. Can't wait to pick your brain on that one. I think I know where you're going. You might be able to change my mind. We'll talk about it in greater detail. And I also want to talk about California reacting to the DOJ lawsuit because they're getting pounded out there, as is Virginia. We have a lot more to cover with AWR Hawkins right after this. AWR Hawkins, welcome back in, man. It's always great to have you here. Let's keep on rocking and rolling with you. The 8-1. Let's go back to the 8-1 for a minute. I want to hear your rationale on that. That fascinated me.
Oh, I mean, it's just like I said. I just think the latest Justice Jackson, she's a wild card and she's an ideologue, and I'm not sure that, it's like Limbaugh used to say about the left, they're immune to facts, and I think nothing describes her better than that. And so I don't see her being moved by argument, by evidence, by anything.
Yeah, that was evidenced, I think, in her response in the dissent that she wrote in the Wolford case. I think that gave it away. Coney Barrett's concurrence was amazing to me. She was just, foretelling us her Second Amendment chops, letting us know that she was going to be okay on these gun cases. I can read into that, and I think I can safely read into that. Hindsight's 20/20. It'll be interesting to see because, honestly, ladies and gentlemen, all 3 of the liberal justices, in one way or another, have already have recognized Bruin's precedent, which means they should be all voting, but they won't. Let's see what happens. Sotomayor, use AWR's word, wild card, because she made it pretty clear that guns in common use cannot be banned. She said it herself in one of her own rulings. Let's move now to California. Again, stay there. California reacts to DOJ lawsuit intimating Glocks are dangerous and unusual. And those are the 2 operative words, dangerous and unusual. AWR, that's how they're trying to get around what they know is coming, isn't it?
Yeah, but I mean, let's be honest. It's stupid, but what they do is they shift from talking about pistols to talking about machine guns. And then after Bonta talks about machine guns, he says, post-Bruin, the Ninth Circuit has held that machine guns are dangerous and unusual. So then he claims, because he presumes his own argument is correct, he presumes his own answer, then he's saying, well, if it applies to machine guns, it applies to Glock. He doesn't say it that way, but that's what he intimates. So Glocks are dangerous and unusual. Well, I mean, a syllogism. I know people know all mortals are human. Socrates was mortal. Therefore, Socrates is human. But if you're Bonta, his line of thinking would be all mortals are human. Socrates was mortal. Therefore, he's made of chocolate. That's how senseless this argument is. And he's going to take this to court. They're going to laugh at him.
Yeah. Oh, yeah.
They're going to laugh at him like I used to laugh at the old Benny Hill episodes when they were on late at night. That's how hard they're going to laugh at Bonta.
Yeah, it's going to be really fun to watch. There's no doubt. Let's talk about people to laugh at. Everytown for Gun Safety. You've got a great piece up. Everytown for Gun Safety worried by reckless Supreme Court cases challenging ban on AR-15s. They need to be worried. And I want your opinion, because you had gone fishing last week, but I want your opinion on how, because they're very quiet right now, what do you think is going on behind the scenes? Let's first address your article, and then let's go back behind the scenes of what you think is happening behind the scenes, because they've got to be scurrying like the cockroaches and rats that they are. They have to be.
Oh, yeah. Well, I just think the bottom line is what they do is they fundraise off of promises to ban these guns. And so they know that if Supreme Court rules, that ability is gone. And who knows how many millions that represents that they take in with all the hysteria they create around AR-15 rifles. And once that ability is gone, they're going to have to find a new way to fundraise. And I would bet you anything, that's what they're doing right now. They're trying to get proactive. They're going ahead and assuming that they're going to lose this case, which I believe they are. And so they're trying to figure out what is a new fundraising tactic we can make so we can keep paying all this money that we pay our executives. And I bet that's what they're huddled up doing right now.
You did, in fact, point out how much money they were making to the tune of $400,000 a year and on up. And that was base pay, ladies and gentlemen. They're paying themselves big bucks. But they're losing. And here's what Everytown Law's Janet Carter said, defending AR-15 bans, as AWR covered. These laws are critical public safety measures, and they are consistent with the Second Amendment. There you have that. You heard that, ladies and gentlemen. 6 federal appeals courts have rightly upheld assault weapons and large-capacity magazine laws, and we urge the Supreme Court to follow suit. The Supreme Court's not going to follow suit. What she's telling you is that those are all liberal courts, activist judges, and Bruin is going to shoot every single one of those down. So can't wait to see that, AWR. I had a request from someone that said, can we end on a happy ending story with AWR? I believe that was Texas Huntsman in the chat. And I figure, yeah, why not? How about I read one of your headlines, and then if you've got another one and we have enough time, we'll also go there. But we have a headline here from AWR Hawkins. And let me find it here. Here it is. Alleged intruder in critical condition after home occupant opens fire. What happened and where? Give us the lowdown. These are happy ending stories.
I can't remember the town. I have to remember the town. Was that Huntsville?
That's Huntsville, Alabama. Yes, sir.
Yeah, that's right. Yeah. Well, I mean, the guy came in, and they told him not to, and he came in anyway. And I believe he uttered some threats, and so he got to see that that muzzle flash. You never want to see the muzzle flash. And of course, what that does mean, odds are that you survived because you can remember seeing it, and that's always a shame. But that's how that goes. But you just I don't know when these folks are going to catch on. I said in Texas, you're completely ignorant if you try this, but in Alabama, you're no brighter if you're trying this. And if this is all you've trained yourself to do, you need to go back to school and get some new training, because breaking into homes is not going to work out well. It's just not.
Yeah, that's not good business whatsoever. And I want to end on a happy note in Ohio. I was born in Cincinnati, so I have a lot of family still lives up there. But 116 school districts now allow armed employees in Ohio. My sister-in-law just retired as a long-serving 25-plus year, 30-year school teacher, and her district allowed it as well. That's just great news, isn't it, AWR? Got 20 seconds.
Sure it is. Classroom defense. That should be our priority. And you can say this is a gun-free zone all you want, and all that does is tell the killer when he comes in, no one will be able to stop him. But if you give a teacher a gun and an administrator a gun, and you don't tell anybody
60.
which teacher has it and which administrator has it, when that guy comes in, he's got to roll the dice. And hopefully after he rolls them, they fill him with about 17 holes. And I'm just talking about his forehead. That's what I hope happens.
Well, here's the deal. Those laws are incredibly effective because the same thing has happened in Florida as well, ladies and gentlemen, as in nothing has happened since they've passed those Guardian programs. And I got to hand it to Jim Irvine and the guys at Buckeye Firearms, who for years started working on this, and they've been wildly successful with the SAFER Act, et cetera, in arming people in schools. And ladies and gentlemen, it has been a big help. AWR Hawkins, we love you, man. Fan favorite for a reason. Longtime OG at Armed American Radio, man. AWR Hawkins, Breitbart News. Just search him up. You'll find everything he writes. Stay up with him. Get some alerts. Make comments on his stuff. You'll love him. When we come back, a classic Armed American Radio Roundtable, 6 after. And here we go, ladies and gentlemen. Hour 3 is upon us. Moves right along. Just boot, scoot, and boogie in Greg and Dallas, Texas, in the Car Firearms Group studios at the Texas mothership. It looks like a UFO with all the bells and whistles and red lights and all the cool stuff going on behind you. How you doing?
Not too bad, man. It was a pretty good weekend.
Did you celebrate hard? Grill hard?
Yeah, I mean, my gosh, yeah. It's
Yeah,
Texas.
right.
We were just throwing down out here. Every direction I turned Saturday night was fireworks, and fireworks within 5 miles of distance.
Yeah, it sounded like a war zone, man.
100%.
It always does, but this one was, the
It was
biggest.
special.
This one was special. It was really something. And, with me, my history buff in me, I just sat and imagine being a resident of Gettysburg when the battle broke out there and what it sounded like, Because
Yeah.
that's kind of what it sounded like.
Or when you're in Hattiesburg out in Mississippi and you're traveling through the historic area, there's a hotel out there that's on old battlefield, and you can still see some of the old cannons and some of the old structures that was out there. I love that stuff.
Well, Gettysburg there's still projectiles in some of the buildings, the historic buildings that have the markers
doubt.
on them that were here. Yeah, it's remarkable. And then you throw in the screaming and yelling and all that stuff going on. It was just crazy.
Yeah.
That's what goes through my mind. That's just, I guess I'm weird that way, I don't know.
Yeah,
I'm a big.
I think about that when I
Civil
go to
War
San
buff.
Antonio for the Alamo.
Well, I'll tell you what, we're live on the phones. Brad Premo, CEO, Lead Slingers, combat vet, and former law enforcement officer. How you doing, my brother?
Doing great, Mark. How are you?
I'm doing wonderful. And, I asked everybody for a headshot today so I could get them up on the thumbnails. And Brad's, they've got you in a Detroit hat, which is the picture you sent me. But it doesn't quite look like you, but it was as close as I could get. So don't be offended if you watch it, okay, on the screens.
Yeah, I saw it. I'm not offended. I thought it looked pretty good, so no complaints here.
Made you good looking, right? It works. I said, hey, do me a
Better
favor,
look.
make him better looking, make him look younger. There you go. Brad Primo. Justin Moon, CEO of Car Arms. Justin, how are you? Happy Independence 250th birthday week. How are you, my brother?
Doing good, Mark. Thanks for having me, and happy birthday, America.
Man, you celebrated up there? I know you did.
Yeah, we had a great 4th of July party.
Yeah, I can't wait.
Did some
for October.
barbecuing.
Yeah, well, you got to do that. Barbecue's the big deal. We'll talk about what everybody barbecued in a little bit. And Ryan Petty, who I would normally ask, where in the world is Ryan Petty today? But Ryan, you just landed. I want people to know your dedication to this program. You just got out of an Uber at your hotel, checked in, went right to the room, and you made it here within 1 minute. How are you, man? Thanks for everything you do.
I made it. If I hadn't done the mobile check-in and had my room key on my phone, I would have never made it. But I'm here. I'm live. I even logged into the video, Mark. I got in.
Oh,
So,
good. Well, you know what? Let's just go ahead and bring you up right now because I see you in there. So there's Ryan Petty. So we can do that, and we can put the other
There we
two
go.
guys' mugs over there. There's Ryan Petty. There we go. All right. So, Ryan, let me start with you because I've got you right now. I just had a fascinating conversation with 1, 2, 3 throat punch, Alan Gottlieb for the entire hour in hour one. I know you were traveling. And that was followed up by Jared Yanis and AWR Hawkins, both of whom met personally with SCOTUS at ATF. We'll go there with the crew in just a moment. But Alan said something really interesting. These are the two cases going to Supreme Court next year that are going to wipe out AR-15, the hardware cases. Both are Second Amendment Foundation cases. He felt this could be a 7-2 decision possibly when I laid down 6-3. Sotomayor's comments, Ryan, might come back to haunt her as I believe it was the Rahimi case. I know it was before Hamani, so I think it was the Rahimi case. Would have been the only opportunity she had when she reiterated that Bruin precedent tells us that guns in common use cannot be banned. Is she a possible vote in a assault weapons ban case?
I mean, isn't it? So, I mean, anything's possible at this point. And with her citing precedents like that, who knows? I mean, anything could happen. Absolutely, it could be 8-1. I mean, I think we can count Jackson not understanding the arguments presented before her, and she'll vote just ideologically the way she always does. But you could get a Sotomayor or a Kagan even going along with it because of the Bruin precedent. We are in unprecedented territory.
Yeah, we are to set precedent. And Brad, what I find really interesting about this, AWR threw out a possible 8-1. And he was thinking everybody but Ketanji Brown because all three of the liberal justices, in one way or another, Brad, over the last 3 Second Amendment cases that have come down, that being Wolford, Hamani, and prior to that, Rahimi, they have all acknowledged the precedent set by Bruin. Now, it didn't matter in Wolford because it was a 6-3, but they have at least acknowledged it. How do you see something like this shaking down, and could we lose it? I mean, let's go there, too.
I mean, I don't foresee any losses. When it comes down to how they vote, I mean, anything's on the table. My guess, though, is that they're going to fall in line. They're going to go more with their ideology as opposed to what the law says. So, I mean, I'd be shocked if it was something less than a 6-3 or something like that. If it was 7-2, I'd be shocked. I don't foresee the other ones voting the right way. I think they're going to vote with their handlers, where they tell them it's not going to matter. We're going to win. So I don't really get too wrapped up in what the vote's going to be.
Yeah, my call. A solid call is 6-3, I believe, and that's just looking back historically and because we're 5-0 at the court, with the makeup of this court, I have a feeling that that's going to wind up being 6-3. It's possible Sotomayor, because of her statements, might have no choice. That could be 7-2 for that very reason. Justin, how do you see this shaking out?
Well, as long as we win, that's what counts. I mean, if one of the Democrats votes with us, I mean, it gives us more credibility, but it really doesn't matter. I mean, it's just basically.
Do we need them for credibility, though, Justin? Really, honestly, do we need them for credibility?
I mean, you know that if it was a swing vote, they would vote against us. So, I mean, it doesn't really mean anything.
Do you fear Roberts at all in an assault weapons case?
I mean, Roberts is the problem. He's voted against us a number of times, but I don't think he would at this point, given the precedents which the court has established, with their current rulings.
Which he has, by the way, been in the majority in all 5 of those cases. I really don't see him, Ryan, shaking out at this stage of the game. It would seem illogical at best if I were Dr. Spock. That's just simply not logical, Ryan.
Yeah, but he's been a bit of a disappointment on a number of fronts, right? And so it's funny that we're having the conversation. Could Kagan or Sotomayor join with the conservative justices in supporting or restoring, as it were, our Second Amendment rights? And the question is really around where Roberts will be. But I think it's probably 6-3. 7-2, something like that. But Brad said it, and so did Justin. At the end of the day, it won't matter. But nice to pick off 1 or 2 of them is that I think it makes it harder for a future court to reverse it. Now, that doesn't mean they can't reverse it, but you've got 2 liberal justices, or at least justices that were put in by by a Democratic president. Difficult, I think.
30.
Yeah, it's interesting.
We'll see what happens.
When we come back from this break, I'll throw one little monkey wrench into the Roberts thing, and then we'll toss it around the table just because we can. You're listening to the Armed American Radio Network on hundreds of radio stations across the nation. If you're watching us on YouTube, and we appreciate if you are, please make sure to subscribe to us over there. We're growing by leaps and bounds. We need you to continue to help us grow over there. Make sure to comment, make sure to like the post, make sure to share the post, and please subscribe, ring the little bell. We put videos out every single day, and you'll get them. Minimum of 3 go up just about every single day for you. Keep you up on your Second Amendment news and the comings and goings at Armed American Radio's Monstercast and the Daily Defense. When we come back, we continue the conversation. We'll stay on. I want to go back to Roberts briefly, and then we'll move on to something else. We'll be right back with the crew. Don't go away. So let's go back to the table, and Ryan, I'm going to bring you back up on the screen here just because I can, and we'll see if we can pull him up. His camera looks blank, but we should be able to hear him. He's in a hotel room. No big deal. But Brad, let me go to you, and I would talk about Roberts for just a moment. You heard what Ryan was saying about Roberts being a swing vote, and as I point out, Roberts has voted with us in all 5 cases. I don't think we lose Roberts. However, If Roberts knows it's a 6-3 and a 5-4 still wins it, if there's anybody on that bench, I could see him trying to make a statement when it comes to a ban, because no ban case or anything like it has ever been taken up when it comes to hardware, Brad. So that is somewhat of a concern. While it's an outlier, it is a concern. Tell me how you feel about that.
Yeah, it is. I mean, it seems to me like Roberts, when he chickens out, he chickens out on the stuff that would, make huge waves. For example, like the birthright citizenship cases last week. I mean, if they had ruled in the administration's favor, I mean, it would have been a big deal, and it would have had some pretty big shock waves. That most of us I think would be okay with. But Obamacare, there's a few other on top of my head, but like he chickens out on the big stuff. Like, to me, the Second Amendment's a big deal to us, but in a lot of ways, a lot of people that they could rule in favor of us on everything, and most people are going to wake up tomorrow and not even notice. And so he's not going to chicken out because he's not afraid of making a big change in the Second Amendment cases, in my opinion.
Yeah, I can't disagree with that. I find it hard to believe that he would backtrack. Justin, you already mentioned that Roberts is a concern. Based on that logic, do you feel any differently about that, or does it push you in either direction as how you feel about Roberts, what he could do on a case like this? Because you're talking about 7-2 gives us more credibility. 5-4, like you said, you're going to take the W. I'm going to take the W, but you're right. I'd rather have it be 6-3 or 7-2 if possible. Should be 9-0. But Roberts could be that issue if you look at it that way, couldn't he?
Yeah, I mean, Robert is a chameleon. He's obviously loyal to the deep state. He's not really loyal to the people. So when he can get away with it, when it's close, he'll always vote for big gov. He won't vote for the people. Yeah, but when it's not close, he's going to pretend like he's conservative and cares about our rights and vote for us.
Let's not forget also there seems to be a little tug of war between him and Trump. So will any of that play? We're just going to have to wait for the oral arguments. Ryan, let me switch it over to you and change topics here, because the anti-gunners, fascinating watching them when they lose. It's always fun to watch them lose, and they lose most of the time. And Cam Edwards over at Bearing Arms has a great column up. Every town attorney's response to vampire rule decision is downright hilarious. And of course, that's referring to the Wolford decision that just came down a couple weeks back. Some anti-gunners are putting on a brave face, while others are simply deluding their followers in the hopes of staving off depression and disengagement. Everytown Law's Janet Carter, for instance, is basically insisting that Wolford wasn't a big loss for the gun controllers, and in fact was actually a disappointment for 2A advocates, Ryan. She said, I don't think that the gun lobby got what they wanted. Well, as Cam points out, she's right. We got everything we wanted and then some. While the decision itself was pretty narrow, the majority opinion fleshes out the text, history, and tradition test in a way that is favorable to those of us trying to protect and secure our Second Amendment rights. The court made it clear that arms are both weapons of offense and defense, that self-defense is not the only reason why arms are protected, and most importantly, that if the plain text of the Second Amendment is implicated by a modern gun control law, then that law is automatically presumed unconstitutional, and it's up to the state to prove otherwise. Here's the scary part. She then predicted that Wolford will not change the minds of lower courts on things like assault weapon bans. And as Cam points out, and we all agree, I think, she's probably right. You think she's right there? Those liberal lower courts are going to continue doing what they do, won't they?
I think so, because, again, they believe they're on the right side of quote-unquote history, right, which is what they tell themselves and how they delude themselves into believing this, into believing what they're doing. Somehow, a higher order way of thinking, right, and the rest of us are just rubes. The interesting thing, though, and Cam is right. We're absolutely got what we wanted and more. I mean, we got Sotomayor admitting, talking about Bruin. We got we got a 9-0 decision. There's so many things that we got that we didn't expect to get, and look, the anti-gunners. This is this is now presented crisis. They have got to delude their followers, their adherents, their sycophants, their money sources, right? They've got to continue the fundraising effort, and so they've got to put the best spin on this they can, because they are in full panic mode, and people get them out of it is a big haul in the fundraising efforts, and so that's what they're going to do.
You broke up a little bit. Did I hear you say they're in crisis?
I think they're in crisis. I mean,
Okay.
after
I
these, and knowing that next year, what's coming next year is going to be the actual hammer, right? And so they've got to put a good face on this stuff, and they've got to fundraise.
Yeah, when we come back from the break, guys, I'm going to take it over to Brad Premo and then Justin Moon. Are the anti-gunners in crisis? Huh? I'm smiling on camera because, yeah, I think they are too. But we'll get a deep dive from Brad and Justin as to why they're in crisis and what that means going forward. If they're in crisis, why are they in crisis? What does that mean? What are they in crisis over? Why are they panicking? What's at stake for them? This will be interesting. We'll start with Brad Premo, CEO of Lead Slingers over there, and then we'll go over to Justin Moon, CEO of Car Arms. Now, of course, Justin is the CEO of Car Arms, and all of their other firearms that they own at Car Arms. Premo, I'm going to throw it back over to you, brother. Let's talk about crisis mode. You heard what Ryan said. Are they in crisis mode? And if they're in crisis mode, why are they in crisis mode? And what do you think is going to happen to them after they lose? Look, I'm going to ask for predictions. What direction do you think they're going to go? Or is this just a nail in the coffin of gun control? We would hope, but that's likely not the case. And if that's not the case, how do you foresee this shaking out after a loss, when they can spin Wolford loss as some kind of weird victory?
Well, I mean, crisis mode is a good way to describe it. And Ryan, I think, hit the nail on the head when he's talking about fundraising, because we got to remember is the people who work at these organizations, I mean, their livelihood depends on having this issue being front and center and being for them, frankly, a moneymaker. And so, they keep taking these big losses in court, and that money that was ordinarily flowing into their coffers is going to get redirected elsewhere to other causes. I think it already is to some extent, because I feel like we're not really seeing or hearing a whole lot from the Everytown, whatever happened to Moms Demand Action.
Yeah,
like,
where are they on this?
Come out. Yeah, I mean they're all over the place, and then it just seems like over the last couple of years, you're just not hearing from them anymore, and a lot of that probably has to do with lack of funds to buy media and things like that. They take some more big losses at the Supreme Court. They lose their ability to push unconstitutional laws. Some of them will surely go away. They'll merge together. They'll go dormant. They'll maybe start work on other issues or something like that, and they'll wait till another tragedy comes along, and then they'll dance in the blood of innocence and come roaring back. Probably, I don't think we'll ever be rid of them. But they're really kind of running out of options to stay relevant.
I think you're right, Justin. Do they just go away? Wishful thinking on our part. And if not, let's assume a huge loss for them in both of those cases. That will be 7-0, by the way. Those are two individual cases being heard the same time at oral argument. That will be 7-0 for them when we win these cases. What happens to them?
Well, they're certainly not going to give up. I mean, they're still pursuing the communist playbook. So, if they can't disarm us through the courts, then given how fragmented our country is and politically divisive it is, they may try to create another civil war. Take two.
Well, a lot of people have been concerned about that for a long time, and with what's coming out of their mouths, they certainly show a proclivity towards violence, Justin. We've seen it in every Democrat-run city. Hell, we see it when they win a basketball game in Philadelphia, for example, or Los Angeles. It's crazy with these big Democrat-run liberal cities. Now, as the CEO of Car Arms, I mentioned this before we were going to a break, not just Car Arms, but Auto Ordnance, Magnum Research, et cetera, and all the great car companies over there. You guys are well diversified. What happens to you, and are you now beginning to think ahead strategically as a manufacturer for a victory. Are you planning on that now, and what would happen? How do you foresee gun sales when the Supreme Court strikes down hardware bans? What happens?
Yeah. For me, it would be great because if the Supreme Court strikes down the assault weapons ban, the Tommy gun will be legal in a whole bunch of states like California and
Yes.
New York and Connecticut and all those areas. So I would love to get back into those markets where real patriotic Americans want to own and have a Tommy gun.
Yeah, that's my guys. I have one, and it is the family heirloom right out of the box. It is the absolute coolest gun I have. It's a Tommy gun, for crying out loud. Ryan Petty, do you have a Tommy gun? If not, why not? And when are you going to get one?
I do not have one. I need one.
Oh, pox on you.
Soon.
You need one. It's the quintessential classic American firearm. There's no question about it. Ryan, same question to you. Not just about the money aspect, but let's talk strategic planning. Brad was kind of going there a little bit. And you know, when you read, you can kind of read the tea leaves. They've been very, very quiet. Very quiet. They don't have a lot to jump on right now. And they know what's getting ready to happen to them next year. And I'm sure they predicted a lot of this, probably not to the extent that they have. Even we didn't predict that. It's been historic times. Well, historic times for us is horrifying to them. But when she predicted that Wolford won't change the minds of lower courts, is she signaling to us that they're going to continue to seek justices in various areas that will defy an upcoming hardware ban that we know will be ruled unconstitutional? Will they try to defy that? And if they try to defy that, what would that look like when the Supreme Court has said you can't ban that?
Yeah, I mean, I think the next step for the left is to try to provoke a reaction or a response, right, from the federal government. So you could see legislators in states pushing, ignoring Supreme Court precedent and continuing to pass laws that they know violate what the Supreme Court has said is constitutional. You could see that continue to happen in an effort to try to provoke a federal law enforcement response, right? This is the left's playbook, right? It's to provoke hope that we overreact in some way that turns public sentiment onto play. And
California is relying, Brad, on the wording on the Glock ban, for example, which will be part of the smackdown, in large measure because of the way they've described the Glock as an assault firearm. Virginia famously did the same thing. That comes back to bite them when an assault firearm is found to be protected by the Second Amendment. There goes their Glock bans as well. But they're relying on two words, dangerous and unusual, which the courts have said fall outside the scope of the Second Amendment. So they're trying to claim the Glock is dangerous and unusual, Brad. Could that be a significant telegraph of what they might try to do, maybe by looking at individual guns, which they've been doing now in various states, New York and California famously as well, Maryland and assault. Pritzker has already said he's going to defy it. He's already pushing for that right now in Illinois. They're all commie losers. But is that what they do? It's hard to get in their heads, but it's fun to talk about.
Yeah, well, I mean, a couple of things to touch on. I mean, I find it pretty humorous. They want to say a Glock is dangerous and unusual when probably I'd had to guess. I bet you half
other
the police
cops carry
departments in
Glocks.
California are issued Glocks. So,
Right.
But that being said, Ryan kind of touched on this, and I think this is where they're going. And to get in the commie mindset is their mindset is that if an election or a court case or anything like that goes against them, that it is therefore illegitimate in their minds. And they will disobey it because they think it has no legitimacy at all.
Well, we saw this after Heller, ladies and gentlemen, when they tried to flip, and they did in subsequent years pervert the Heller decision. to make it all about them and claim a victory, even in Heller, which has laid the framework for everything we're talking about right now. It's fascinating how they operate. When we come back, I'm going to give you a personal thing that happened to me over the weekend and talk to about it with the crew. I'm going to turn it right back over to you. I've got something fun I want to talk with you guys about right now. You want to go into something new here? Justin, you there? You with me?
I think you might have muted.
Did Justin mute? Did Justin mute?
He's still there. He's still connected to us.
Okay, well, hold on a second. Here's what we're going to do. Ryan's going to be able to see this. Well, radio is theater of the mind, so let me play this with you, ladies and gentlemen. If you're not watching, you can get an idea. But up on the screen is a picture that I took of myself, a selfie, coming out of a, let's just call it a store for now. Okay? I saw this after I left the store. It is myself standing in front of a no guns allowed sign. Now, these are very few and far between in the state of Georgia. Very few do we see of these. They do not carry the weight of law in the state of Georgia. You can ignore them. You are not violating law. Georgia is smart enough to understand that something's policy is different than law. And if you've ever watched any of the First Amendment audit videos, you're law enforcement, not policy enforcement. Unless you're seen carrying a firearm in that establishment whose policy is no firearms, and you're asked to leave and you don't. So what you see is me up here with in front of, pointing up behind me, and behind me against the wall. All weapons, including concealed firearms, are prohibited on these premises, and it references OCGA section 1610-127-1. Now, if you know anything about Georgia law, most of you probably do not. I did go up and bone up on this, and as I thought, that's the school zone code, which does not address anything other than how in the state of Georgia they can't tell their employees or anybody else that they can't have a gun in their parking lot. And from every word I've read, this is a stretch. So I laugh at these signs, and I had a couple, I think it was Media Matters that came after me and wrote an article about prominent pro-gun rights radio host ignores the law in Georgia when I was talking about going into Costco, guys. Now, I will tell you now that I am never unarmed, and I walked through this establishment armed, again with my Car X9, Justin, and an extra magazine, and went about my business, came out. This is the first time I've ever seen that sign there. I cannot believe in all the years I've gone there that I've never seen it before, because it was right there next to the entrance door. I would have seen it before. So I'm not sure when that went up or if I've just been blind for the last few years. None of that matters to me because I flat out ignore it. And I am not breaking any laws in doing that. So I turned it into a YouTube short that got a lot of hits, and that is, what would you do in a situation like this? And Justin, I'll start with you, because when I see, I don't know what, maybe you can tell me what the law in Pennsylvania is if it's posted no gun. What is the law in PA? I should know that, and I don't. I apologize. I'm going to rely on you, and I don't mean to put you on the spot.
Well, the law in PA says that if it's posted, you can't bring a gun in there. So,
so is that a violation of their policy, and they can ask you to leave? And if not, then you can be charged with a crime. In Arizona, you go past that sign; it's against the law. Period.
They could charge you with trespassing.
Okay.
If it's posted.
Yeah, and in most locations, if you're trespassing armed, that can be a felony. Ryan, Florida, update us now, because this is a good segue into pushing Florida carry that we're hitting on right now. In the state of Florida, again, these signs are very few, but what is the status in the state of Florida? Can you enlighten us?
I can. It's similar to Georgia. It's not a crime. If an employee or the business owner sees you carrying or recognizes after they've posted the sign, they can trespass you, that's basically what they can do.
But only if you refuse to leave. In order to be trespassed, you have to be asked to leave and refuse.
That's right. That's right. But that's really their recourse in Florida.
Okay. Now, Brad, I don't know if Tennessee law has changed, but I remember being up. When the kids were little, we would take them up to Chattanooga and do the whole, the train thing for Christmas and Santa Claus from the movie. And there was a couple barbecue restaurants we would go into in downtown Chattanooga that were wonderful. And one of them was interesting because I know in Tennessee at that time anyway, and it's likely changed, that if there was a no gun sign, you could not enter the establishment period. Those did, in fact, carry the actual weight of law. I don't know. My first question to you will be, has that been changed? The other thing about that was the signs had to be posted visible at every entrance. It was interesting because this restaurant had 3 doors, 2 on the side and 1 in the front. And the front door did not have the sign. The 2 side doors did, and I didn't see them until after I left. Yet, I know how to carry my gun. It was concealed. It didn't matter anyway, but I believe I was violating the law. I would have had an affirmative defense because that sign was not visible at the front door that I entered. It was only visible on the 2 side doors. Has there been a change of law in Tennessee, Brad?
No. I mean, you would still be looking at a misdemeanor if that happened. However, one thing in Tennessee, you are correct, it has to be posted at every entrance. The law also explicitly states the exact wording that has to be on the sign for the sign to be in effect. And probably 99% of all the signs that I see do not have that wording on there. The one thing Tennessee did change, though, is that if a business or if they prohibit the carrying of a firearm on their property, they are then 100% responsible and liable for your safety. And if you are a victim of violent crime on their property, then they are civilly liable to you to pay your damages since they didn't allow you to carry a firearm.
You know, it's remarkable to me that they would even take that chance. And, Justin, I'm going to close out with you because a big victory in Pennsylvania by virtue of the fact that the Supreme Court denied cert in the 18 to 20 carry ban, 18 to 20-year-olds, the law stands now in Pennsylvania and
60.
that particular circuit. Justin, I'm sure you were aware of that. If not, congratulations. Yet again, we can thank the Second Amendment Foundation. Justin, you know what they're doing.
Absolutely. It's always good to see the Second Amendment move forward here in Pennsylvania. And hopefully we continue. You know, we don't have constitutional carry in Pennsylvania yet, and
We
you
gotta get
guys
that
are
next.
still way ahead of us.
Yeah, but you guys are closer than others. Let me put it that way. It only will take a couple things to happen in Pennsylvania for that to occur.
30.
Eventually, that may become the law of the land as well if it were to go to SCOTUS. Ryan Petty, God bless you, man. I know you're busy. You've been traveling all day. Thanks for jumping on with us. We do appreciate it greatly. Brad Premo, CEO Lead Slingers, combat vet, ex-law enforcement, thank you for being here. You OGs are beautiful. And, of course, Justin Moon, CEO of Car Arms. Guys, we're going to get up and do it again tomorrow. Enjoy your day. We'll see you on the radio. Hey, guys, thanks for being here today. I appreciate it very much. Although, if you're new to watching the show, thanks for tuning in. We hope you enjoyed it. It was a great program. Flies right by the 3 hours on Sundays. We will be live for you again right here on all of these platforms, regardless of which one you're watching. Like us, subscribe to us, share, post, comment. Please get involved. It really feeds that algorithm and helps us grow. And we are growing by the hundreds of percentile on all of these platforms. YouTube is the most important for us right now. So if you're watching on YouTube, please make comments on there. When you see the shorts, ring the little bell so you get the notifications. We're always putting something fun out. No doubt we will have some videos go up tomorrow, long-form videos and some shorts with both Alan Gottlieb, AWR Hawkins, Jared Yanis, and a couple clips from the roundtable because we're just content factory here, and it's perfect for us now that they've opened up on those platforms, and we do thank them for that. Please go out of your way to visit all of our great partners. Again, you can find them all at armedamericanradio.com. Hope you enjoyed the show. I love each and every one of you. Thank you for being here. I'll see you live on the radio tomorrow, 4 p.m. Eastern, 1 p.m. Pacific. Stay safe out there, guys.